Kurt and I decided that we would focus on 2015 cases. So in our materials that you have in the binders, which will also be available on our website, there are a lot of 2014 cases as well, but we will be skipping around to the 2015. We only have a limited amount of time. I'm going to be covering the first few cases are under the assumption of risk section. And fortunately, under that topic, there are 4 cases from 2015. And a couple of them, their issues overlap, so I can kind of address them together. The first 2 cases that I'll be talking about are Chavez versus 24-Hour Fitness and Jimenez versus 24-Hour Fitness. Poor 24-Hour Fitness got sued a lot that year. They both for people that were injured in their facilities, and they are both cases that were on summary judgment motion, and also both having to do with gross negligence. You all have been many places where you sign off on a release. When you enter a facility, you go skiing, the back of your ski ticket releases all kinds of things. You sign up your kids for gymnastics, you sign a release. They go on a field trip, you sign a release. Are those things actually enforceable? It's the law on that, case law on that is waxes and wanes in enforceability. Both of these cases held that the release that the people signed when they first signed up to be members of 24-Hour Fitness were enforceable as to negligence, but not as to gross negligence. So you are unable to waive liability for gross negligence in a release. But they did affirm that in both of those cases that they are enforceable for just standard negligence. In the Chavez case, a panel from a cross trainer fell on the person and really seriously injured her, traumatic brain injury. She had signed the release, waiving general negligence claims. However, and at the trial court level, the court granted the summary judgment motion, filed an appeal, saying that there were triable issues of material fact as to gross negligence. It was overturned. The court determined that for gross negligence, the standard that's applied for that level of negligence is want of even scant care or extreme departure from ordinary. It was found that they failed to perform regular maintenance with passivity and indifference. And those are the standards that are applied when you're looking at a gross negligence issue. And so they overturned that at the appellate court level. All the cases I'm talking about today, there's no indication that there's any Supreme Court activity, so they're good law, and they don't look like they're being appealed further on. The other issue is that it's important to attorneys that you work with when you're thinking about filing a summary judgment motion is that you have to have all of your ducks in a row before you file the motion. But sometimes you find that you need to do some more discovery to oppose one. A plaintiff's attorney will find that they need to do some more discovery to oppose the summary judgment motion. And in this case, along with filing an opposition to the summary judgment motion, they also did a motion to continue to stay the motion and to be able to do some further discovery. And the trial court denied the request for continuance, which is pretty brutal. I mean, you have a case, someone's injured, and you think, well, the court should allow the discovery that's necessary to be able to try the case on its merits, if possible. So it's a pretty serious result not to allow a continuance to do some discovery, take some depositions. And that's what the appellate court determined, was that was a very extreme result, and weighing the delay, what's it called, the Delay Reduction Act, which is trying to get cases through the system faster. Well, you want to do that, but you also want cases to be tried on their merits, so whenever possible. So they also overruled the continuance at the appellate level and said that was not a good ruling on the refusal to allow the continuance to be able to engage in the discovery necessary to respond to the summary judgment motion. So in Jimenez, the other 24-hour case, fitness case, the person fell off a treadmill and ran into the machine nearby, and again, severely injured. There was a brochure, a manual that went along with the treadmill. It said that you shouldn't have any other equipment within 6 feet, a zone of safety. And it was determined to be approximately 4 feet away from the treadmill. And they found that was, they won on the summary judgment motion, and again overturned at the appellate level on the finding that there were issues of material fact regarding gross negligence. Again, affirmed negligence as they signed the same release, but found that the release cannot absolve a party from gross negligence, and that there was a genuine issue of material fact regarding the safety zone issue. This case is also interesting from the perspective of there was a side issue, again, not the continuance issue, but a different issue, and that was that the person that signed up for this 24-hour fitness couldn't speak English. She was Spanish speaking, and apparently when she signed the release, the salesperson did exercise motions, and then he pointed at a number on the screen, and like, you get to exercise for $24.99. And so then she signed the release, and they found that was a fraud in terms of getting someone to sign off their rights based on that limited ability to understand what they were signing. And so that was a side issue on this case, and they found there was a genuine issue of material fact as to whether the fitness center procured the release fraudulently from the patron. And so those two issues are addressed in that case. Then we have another release issue, which went the other way. In the Erickson case, and I should switch it now. I don't know if that's working. All right, thank you. Low tech. Erickson versus Nunique. This is a sad case. There was a young girl. She was a horse competitor training 3 days and 3-day events, and she died in an accident in a competition. And this is a very long case, but in a nutshell, the mom signed a release. The coach coached her based upon the release, and that the court found on appeal that the release was unambiguous, that it released the coach from liability. The parents had a burden of establishing gross negligence. They did not meet that burden. And the coach did not owe a higher duty to the parents than to the rider that she coached. And so in this case, they again enforced the release, and there was no liability found on behalf of the coach. And again, in those other two cases, they found that there was a triable issue material fact as to the gross negligence standard, but in this case, they said that the parents did not meet the burden of establishing the gross negligence standard and enforced the release provision precluding liability against the parent, against the coach by the parents' claims. And then finally in this area, there's the case of Fazio versus Fairbanks Ranch Country Club. And this case involved a performer. He was getting ready to perform at a event at the country club, and they were setting up a stage much like this, probably a lot bigger. It was in some hexagonal forms, and as he was preparing the stage and getting ready to perform, he fell off of it and sustained substantial injuries. And the summary judgment motion that was filed by the country club was found that there were no genuine material issues of fact regarding the dangerous condition of the stage, and also that the plaintiff had assumed the risk involved with performing on the stage. And the appellate court reversed and said that that there was a genuine issue of material fact as to whether or not the club increased the risk of falling by the way that it was installed. So that there was one issue regarding increase of the risk, and that there was a genuine issue of material fact as to that sub-issue, and so overturned the decision by the trial court. Now, this case also addressed the assumption of the risk. That was not an issue in those other three cases, and the plaintiff argued that he did not that his assumption of the risk did not come into play in a performer's stage performer's job duty, and the court said no, we don't agree with that. That there is assumption of risk when you get up on stage to perform and set up, but they found that there was a triable issue of fact as to the increased risk by the manner in which the stage was installed. So those are the issues on the assumption of the risk and releases, and just generally the takeaway is that those releases seem to be enforceable, only not as to gross negligence. And that there can be some issues there and lack of enforceability if there are elements to the facts that lend themselves to gross negligence and to that scant want of scant care or extreme departure from ordinary expected conduct. And so those are the issues that you would want to take a look at when considering summary judgment motions. And so Kurt is we're going to move on to...
Why don't you move on to the Regents, University of California versus Superior Court under our negligence section?
I don't think we have that one in here, Kurt. So you just go ahead.
Don't even go there.
I'm not even going to go there. Go ahead.
Okay. One further comment about the cases that Christine was talking about. I will tell you that trial courts give great weight to express indemnity clauses if they're well drafted. It is a heavy burden the plaintiff has to show something of an increased risk and or some gross negligence. Almost in every case where you have an express indemnity agreement, you're going to, just as a practical matter, it's a necessity probably in almost all cases to bring a motion for summary judgment. Trial courts do give a lot of deference to those written documents, depending on the facts. Those documents are drafted so as to preclude liability from the many sporting activities that we all participate in. So you do have, despite allegations of gross negligence or increased risk, you do have a pretty good shot at summary judgment at the trial court. But let me get on to some negligence cases. The first one I talked about is Regents of the University of California versus the Superior Court. And in this particular case, the Court of Appeal contracted liability. The facts of this case were that a UCLA student that UCLA was aware of had some psychiatric problems, erratic behavior problems, but he was admitted as a student. There were, however, in his psychiatric records, no indication that he had what's called homicidal or suicidal ideation. He just had some psychiatric problems. He and another student, he attacked another student. There was no history between those students of any prior altercations. The student was injured. He sued UCLA, claiming that they owed him a duty to protect him from this other student who they had knowledge of had some psychiatric issues. And the trial court granted summary judgment in the favor of UCLA, stating that there was no duty owed. The case was appealed. The appellate court upheld the trial court's grant of summary judgment in favor of UCLA. And their reasoning was, as you may know, in many instances, when children are attacked in primary school or high school, it's a different situation. The court looks at that as because you have to go to school, the law requires you to go to school, and their children, that the school is kind of in loco parentis, as it's called. They have stepped into the shoes of the parents to protect the child, and if they have knowledge and notice that someone is a danger to the child, the courts in those cases have at times found a duty exists to protect the child. However, the court looked at the case with the UCLA student, first noting that they were both adults, and second noting that attending college is a voluntary activity. And based on those factors, and that there was no direct threat providing notice to UCLA, the court found that no duty existed on behalf of UCLA. They had no special relationship to protect a student, and in that case, upheld the summary judgment in favor of UCLA. That is the one case where the court contracts liability. In the next three cases I'm going to talk about, the court expands liability. The next case is a situation that, at least in my youth, was relatively common. And the case is called Navarrete versus Meyer, 2015, 237 Calap 4th, 1276. The facts of that case are facts that, I have a teenage daughter now, are all too frightening for me as a parent, but as a teenager were very common. In that particular case, a young driver and his friend are in a car. They know of an area where there's some dips in the street. They decide amongst themselves, hey, let's go to that street, drive really fast down that street, and when you hit the dips, the car will go up in the air and we'll have a good time. Unfortunately, as all too frequently happens with young drivers, lost control of the car, crashed into another car, causing a wrongful death accident. Plaintiff's counsel sued both the driver and the passenger, for obvious reasons suing the driver, but sued the passenger under a theory of civil conspiracy and a violation of a vehicle code section, which states that one shall not, and I'm just paraphrasing here, one shall not willfully interfere with the safe driving of operator of a vehicle. The passenger's counsel brought a motion for summary judgment, claiming my person was simply a passenger in the car and had no duty owed to the eventual person who was injured in the accident. Trial court granted summary judgment, went to the appellate court. Appellate court reversed. The appellate court decided that there were facts indicating that had been presented that the passenger had, it was the passenger and the driver's plan to undertake this unsafe driving. That this was their idea, that they would both go down and drive fast down the street to catch you. The appellate court referenced a case from 1960s where a pair of drag racers had decided they were going to have a street drag race together, and one of them crashed into a third party, causing a horrific accident. But the court said in that case, the drag racing case, both people who agreed to the race, the unlawful drag race on city streets, were equally liable because they had agreed to an unsafe activity, and the ultimate result of that unsafe activity was the horrific accident. And the court said in this case there were facts indicating that they had both agreed to undertake this unsafe driving down the street, going over the dips, and the court found under that, potentially, arguably, a civil conspiracy to enter into an activity that was unsafe. The court also found that that vehicle code section that I cited did not require any physical act on behalf of the passenger, such as grabbing the wheel or reaching over and stepping on the brakes. It was enough that they were urging the person to undertake this unsafe activity. Whether the result of that at trial will be successful with the jury is unknown, but obviously the passenger was potentially liable for this horrific accident. The second case that I want to talk about that creates a greater, where there was the Court of Appeals expanded potential liability, is the case Conti versus Watchtower, Bible and Tracts Society of New York. And this was a church-based operation where the elders of the church were aware of a troubled past of one of their parishioners and people, a person who worked for them in a volunteer capacity, had a history of pedophilia. The court found and a member of the church sued on behalf of their child because a similar incident had occurred. The court looked at that and said, though the church had no obligation to tell every member of the congregation about this individual's past, to the extent this individual was involved in church activities that involved minor children, and they had put in place plans so that he would always be watched, and that apparently did not occur. Once they had that knowledge and undertaken that duty to create some policies and procedures to protect children, and then didn't follow through with those policies and procedures in this particular case, the court found that they are potentially liable for the occurrence of this horrific act. And I think I'm going to actually jump next to a products liability case, and it's Johnson versus United States Steel Corporation. And this one's a little tricky. In this case, it's so tricky I'm going to look at my notes. In this particular case, the plaintiff was an auto mechanic. He came down with leukemia. He claimed that the leukemia was caused by certain solvents and products that he used during his career as a mechanic. One of those products was Liquid Wrench. Liquid Wrench was produced by one company, but one of the aspects of it, one of the component parts of it was a chemical called, this will have to, raffinite. That may not be the actual name of it, but that was a component part of it. U.S. Steel had provided that particular component part of Liquid Wrench, that chemical to Liquid Wrench, who developed the Liquid Wrench solvent formula, and they were sued on a products liability theory. U.S. Steel made a motion for summary judgment claiming, one, they were a component part and the component part doctrine should apply, and two, it was, the evidence was insufficient to prove that this particular substance was the cause of this person's leukemia. The appellate court reversed in this situation and took a detailed analysis looking at products liability law. And first they looked at the component part doctrine. And that doctrine allows people who provide component parts not to be found in the chain of production and potentially liable in products liability situations. But in this particular case, the court felt that U.S. Steel had not met its burden of proof to establish that its product was not defective in and of itself, and that the defect in its component, in its product that was a component part, was not the cause of injury. The court went on further to then look at whether this component part, this chemical, whether there were sufficient facts under the consumer expectation doctrine of product liability to determine whether it was foreseeable, not foreseeable, but whether this particular product would be known to the general public as unsafe. And the court first looked and said no one would know that whether this particular product was unsafe because it was not something well known, whether it was unsafe or safe. But taken as a whole, a reasonable consumer, if this product was added to the liquid wrench, if that made liquid wrench less safe, the court found that there were tribal issues of fact to determine that, that hadn't been determined and needed to be determined by a jury, because there was evidence that by the inclusion of this particular product, the liquid wrench was less safe. This was a big blow to a lot of people far down the line in production, potentially making them liable for component parts. And that's kind of where we were with that one. And I think I'm going to pass it over to Christine.
I'm going to go backwards and do Neely versus Santa Monica, which is an employment case. And I'm going to go quick because, as you know, we got a late start, and I don't want to jam up the rest of our speakers and our program, so I'm going to try and address this very quickly. This is another case on a summary judgment motion, and it's an employment case. It's the only employment case we're going to talk about today. And it was brought by an employee against the city of Santa Monica. He was in the recycling and garbage waste removal aspect of the city's employment, and he brought in an action under the Fair Employment and Housing Act claim, commonly referred to as FEHA. The facts of this case are also very lengthy. This employer went through committee meeting after committee meeting trying to accommodate this person for years. He had very serious knee and back problems, and part of his job required the moving around of bins that were weighed between 750 pounds and 1,200 pounds, depending upon how much was in them, and he had very bad knee and back problems. And so they went through many years trying to accommodate him during different surgeries and different procedures. And it seemed to me that this employer went way beyond what many employers do, attempting to engage in the interactive process to try to accommodate someone with a disability. But nonetheless, when they ended up being unable to accommodate him, he filed the lawsuit, and the city won on the summary judgment motion that was filed, and there are various issues in this case that the court held, and this will be a very important case for a variety of reasons in the future for attorneys determining whether to file cases like this, and also for defendants as to how to remove themselves from these cases or issues to spot. And so this case is also regarding the continuing violations issue. So it's a 1-year statute of limitation unless you can establish there was a continuing violation. He alleged that there was an ongoing violation. He asserted no facts to that effect. And the court found that, that he did not satisfy the continuing violation doctrine, and therefore the 1-year statute of limitation applied. The court also found that the employee was unable to perform the essential functions with or without reasonable accommodations, and that is the standard. But in order for the employer to weigh in on that, the employer need not eliminate an element of the job duty. So to accommodate someone, you don't have to accommodate them by saying, okay, you no longer have to do this part of your job. There's other manners in which you can accommodate, but that is not one of the required things by an employer to do to remove elements from a job. Reassignment, the court determined, was also not required by an employer if no position that the employee that was qualified for was available. So for example, he was out in the field. He was not an office worker. One of the arguments made by the plaintiff was that they should have offered him an office job, an administrative position. They allowed him to apply. He couldn't pass the tests. So just because there's a position available, if you're not qualified, that is not a reasonable accommodation for someone that is wanting to keep their job. You do not have to eliminate elements, nor do you have to reassign if they're not qualified. Further, the court found that although a finite leave of absence may be a reasonable accommodation, that an indefinite leave of absence with no end date is not reasonable and is not required by an employer. So those are very important tools for an employer, from an employer perspective, and important findings that will be applicable to many employers dealing with attempting to accommodate their employees in these situations. And the one final holding was that many times in a FEHA claim, the most powerful claim is actually a retaliation claim. So there may not have discriminated against someone for their under a protected class, but they can establish that they were retaliated against because they made a claim or something like that. And the court found that in this particular situation, that just by seeking assistance to and engaging in the interactive process did not amount to a protected claim for retaliation purposes. So just the fact that you're engaging in trying to be accommodated doesn't put you in a protected class for retaliation purposes. So that was a final finding in this case. Kurt, where are you moving on to?
I am moving on to statutory offers, Kahn versus Dewey Group.
All right.
215, 240 Calab 4th, 227, I believe it's on page 34 of your materials, and the following case. As this is probably as pertinent as anything to your work in the insurance industry is statutory offers. Statutory offers, as you probably all know, you can make it any time in a case up to 10 days before trial. Plaintiff or defendant has 30 days to accept or reject. If they make no action, it's rejected as a matter of law after the passage of the appropriate period. The impact of rejecting a statutory offer is that there are post-trial fees if you do not beat the offer. If you're a defendant and you make a statutory offer early in the case is heavily litigated, and you incur hundreds or tens of thousands of dollars in expert costs. Case goes to trial, and the plaintiff does not beat the statutory offer. You may, if they rejected the statutory offer, you should be able to recover all of your expert fees post-trial, which obviously can neutralize a verdict in favor of the plaintiff. These cases tend to show, though, in my mind, that it's not the end of the ballgame when you make a statutory offer. You need to make it with a great amount of thought to it, because they can become their own litigation after the case, depending on the size of the cost shifting that you're looking for. In the first case, Kahn versus Dewey Group, a plaintiff sued 20 defendants. The 20 defendants made a global offer to the plaintiff for settlement. 14 of the defendants got out of the case through either summary judgment or motion to dismiss or some sort of pretrial motion. They all sought, based on getting out of the case, to recover their cost fees and expert fees since the time of the rejection of the offer by the plaintiff. This all went up to the Court of Appeal. The Court of Appeal said, nice try, but you're too early. You made a global offer with the other 6 defendants who were still subject to trial. You cannot, because it was a global offer and you're all tied together, you cannot tell who the prevailing party is. You can't tell whether the plaintiff actually is going to beat this offer. You have to wait. That's kind of the nuts and bolts of that case. But it does show that a offer from a number of defendants joining together can be successful and can be a powerful tool. You just can't enforce it before everybody wins. The second case is Litt versus Eisenhower Medical Group, 237 Cal App 4th, 1217. And this is another adventure in post-trial litigation. One defendant made a statutory offer to the plaintiff. Plaintiff rejected the offer. That defendant beat the offer at trial. The judgment was smaller than the offer. That defendant sought to recover the expert fees that they had incurred post the rejection of the offer. Plaintiff's counsel argued that the expert fees had in fact been paid by the other defendant for the defendant who made the offer under some contractual indemnity agreement or something like that. And their argument was because the defendant didn't incur those costs, those shouldn't be recoverable and be taken off the whatever judgment that the plaintiff recovered. The plaintiff also moved to recover their statutory costs, and the other defendant, who didn't even make a statutory offer, claimed that they were entitled to recover their fees based on the other defendant's statutory offer. The trial court made a number of conflicting rulings, and it all went to the appellate court post-trial. The appellate court found, which seems kind of simple now, that the mere fact that you had somebody else pay for your expert fees doesn't impact your right to recover those expert fees if the plaintiffs did not beat the statutory offer. So the defendant who made the offer was able to recover their expert fees. It didn't matter who paid the expert fees, they were recoverable. The defendant who didn't make a statutory offer could not piggyback on the other defendant's statutory offer. So they were not able to recover their fees, and they had to pay the plaintiff's statutory costs. After trial, you're entitled to recover your witness fees and a whole bunch of other costs, but not expert fees. So that's kind of the outcome of those statutory offer cases. At least from my perspective, statutory offers should be made to better your position to potentially resolve the case. The fact that you potentially can recover expert fees after a successful trial if they rejected the offer, it's a good idea and it's great, but many times plaintiffs are impecunious, can't pay if it's a large expert fee. And you can end up in these situations where you're going to the appellate court fighting over $20,000, $30,000, $40,000 in expert fees, you know, and it's pretty much a break-even point. So, you know, at least my general advice, to the extent you can use statutory offers, looking way, way down the road, probably, even though it has some impact down there, it's probably better to look at it in the near, can it help you get to settlement, or can it help you really protect yourself in a case? But that's all I have there.
And I think that we have to cede the time to the next speaker, because otherwise we're going to be backed up. So unfortunately, we had about 3 other cases to talk to you about, but I don't want to take away the time from everyone else that's speaking. So we're going to go ahead and close, but we are available after to talk to anyone about any of these cases that we've presented on, or any that are in the materials. All right, well,
Hey,
thank you very much.